My name is Daniel Marchese, and I'm a senior trial attorney at the Marchese Law Firm. At the Marchese Law Firm, we focus exclusively on divorce and family law issues, including custody, child support, and spousal support, and post-judgment issues. When people come in for a consultation, I found over the years that people generally ask the same questions. So we are producing videos to help provide information to clients in advance of the consultation, or just to provide general information that can be helpful to those seeking information, more information about the divorce and custody process. A common question we receive is, how do I get the paperwork started? When you get the paperwork started, our firm will give you 3 forms for you to fill out if you have minor children, and 2 forms or 1 form to fill out if you don't have minor children. Those forms are found on our website, and they're clearly labeled under the Forms tab on our web page header. So you can click that tab and you can find all the forms and instructions you need to get started. When you receive the paperwork back from the court after you file, one consideration is, how are you going to break your news to your spouse? So that's why we advise to have a conversation with them beforehand so they know it's coming. Blindsiding someone is never a good idea because it causes unnecessary contention and it could raise issues that could be unavoidable in the future. If there are safety issues, you could call the spouse and let them know. You could have the attorney write them a letter. You could leave for the weekend. There's several things that you can do to keep yourself safe. So when children are involved, there are different variables that you will need to speak with your attorney with at the time to understand what is best to do in that situation, whether you should take the kids somewhere for the weekend or stay home with the kids or have someone come over to watch the kids. There's many different things that you would need to consider during that time, so it's best to consult with your attorney to figure out what's best in your particular situation. As it relates to children, when you are filing for divorce or talking to your spouse about it, it's probably not a good idea to break the news to your children, especially if they are younger children. It's important in divorce cases when you have children not to triangulate the children into your divorce issues and adult issues. It's very confusing, particularly for young children, and even with older children it becomes very emotionally draining and taxing. And if you are continuing to live with your spouse, even if it's amicable, letting your kids know about the divorce situation is an extremely uncomfortable conversation, and it's not appropriate at all. However, at some point, if someone has to move out, if a parent has to move out, or the divorce process is coming to an end, then at some point you're going to have to figure out how to break it to your children and be able to talk to them. So a professional can help with that, a lawyer or a therapist or a psychiatrist or a counselor or a religious person, anything that might be helpful in transitioning the information to the child. Another common question we receive is, how do I get my spouse the paperwork? If your spouse has an attorney and they contact our client about that, then we will send the attorney the paperwork, and the attorney can accept service. The other party does not have to be served, they just have to accept the paperwork somehow. So they can either do that personally by coming into our office, or they can have their attorney contact our office. A party cannot personally serve the other party, so handing your spouse the paperwork does not effectuate proper service. So after the spouse is served, then what happens next? Well, the Michigan court rules now require that each party fills out a financial disclosure form. This form allows each party to disclose all of their assets, and each party is required to do so. This form requires the parties to disclose their income and their assets and liabilities. This helps move along the process. It's due 28 days after the spouse files an answer to the complaint. Once the financial disclosure forms are submitted and exchanged, the attorneys or the parties look over the documents and make sure everything is complete. We look for accuracy in information. We look to see if there's any dissipation of assets, if paychecks are being deposited, if money is being moved, if money is being hidden, if there's cash withdrawals, and several other things that raise red flags. If we see red flags, then we can reach out to the opposing party's attorney and we can ask for more information. We can also send out additional discovery requests or subpoenas to help provide that information if people are unable or unwilling to do so, and that helps us fill in the gaps to get toward a financial settlement. So if we don't see any red flags, then once we have all the information compiled, we speak with our clients and we prepare a settlement proposal that we send over to the other party and their attorney if they have one. How do the parties reach an agreement? The focus on a divorce case is the parties working together, a lot of times with their attorneys, to help reach a final settlement. A final settlement is ultimately a compromise where the parties agree to divide their assets, pay spousal support if that is applicable to their case, and deal with custody and parenting time and child support issues if the parties have minor children. After the financial information is disclosed and the attorneys work together and exchange settlement proposals, the attorneys and the parties will have a good idea of where they agree or where they agree to disagree. Once those issues are identified, then it can become more complex in terms of resolving the issues, and the parties may need mediation. Mediation is where a third-party attorney steps in and helps the parties and their attorneys resolve the issues that they cannot agree upon. A mediator could use references from a judge, what they think the judge might do, what might happen based on their experience. Mediators usually have years and years and years of experience. They practice in these areas for a very long time, and they're very knowledgeable in helping to resolve cases. More than 99% of cases are resolved at or before mediation because the parties and their attorneys are able to work something out. A lot of times we ask, how long does the process take? A lot of people say, I want to be divorced, and I want to be divorced as soon as possible. Well, we can do that for you, but it depends on whether the parties are working together or not, and whether you can reach an agreement. In a divorce case with minor children, the soonest time you can be done is 4 months. There is a statutory 6-month cooling off period, but it can be waived if there is an agreement that is in the best interest of the minor children. And the court would have to approve that agreement. If you don't have minor children, then the soonest time you could be done is between 60 and 75 days when the court sets their first hearing date. At that time, the judgment and all documents would be presented to the judge, and your case would be finalized. If you're unable to reach an agreement, then at the first court hearing, the court will order the parties to go to mediation and for the parties to pick a mediator to help resolve the case. If the case has to go to mediation, generally, on average for the case with the minor children, it could be anywhere from 5 to 9 months, and a divorce case without minor children could last anywhere from 3 to 6 months, depending on the issues. Very rarely do cases go over those maximum time frames, but sometimes there are exceptions to the rule that do cause that to happen. A common question that everyone has is, how much does an attorney cost and how do you bill? Our firm takes a retainer up front, and we bill hourly against that. A retainer can vary in range depending on the complexity of your case, the time that we believe we will spend on it, and the amount of effort or contention that could be involved in your case. Generally speaking, when we quote a retainer, it's what we think your case will cost. However, your case could cost more if you have to go to court because you're litigating issues, if you have to mediate your case, if you have to go to trial, if there's an excessive amount of communication, if one spouse is particularly unreasonable, if one attorney is particularly unreasonable, then those are a few of several variables that can add to the time and expense that your case could cost. Thank you again for watching this video. If you have further questions, please call us at 248-270-2709 or visit us on the web at www.michigan-lawoffice.com. Thank you so much and have a great day.